We are live, and I will treat the
be sure you record.
address and tag John and Aaron. Good evening. If you are listening this foresee dialogue on a very, very crucial topic of who should represent the state of Myanmar at the International Court of Justice in the upcoming public hearings in The Hague. And if you're listening to this roundtable by very distinguished legal minds from two different countries, Canada and USA. If you're listening this from Europe, good afternoon. If you're from the US and Canada East Coast, very warm good morning to you all. I'm Zani. I'm an activist and a Burmese researcher with the Forces of Renewal. And so we have this very important development that is marked with a lot of uncertainties and against a backdrop of essentially a society-wide armed and non-violent revolt against the illegitimate and very, very unpopular military that has usurped power from the democratically elected government of National League for Democracy. To discuss some of the most fundamental legal issues, such as on what legal basis has the judges of the ICJ decided to proceed with the Gambia versus Myanmar, despite the fact that Myanmar junta has been excluded even from the Association of Southeast Asian Nations with a very, very low bar on human rights and political and civil rights. And also Myanmar junta, to remind the viewers, do not have representation at the United Nations General Assembly. The seat for Myanmar is occupied by pro-democracy permanent representative Mr. Jo Moton in New York, and the Credential Committee has decided to put off the question of should Myanmar junta be allowed to send its representation instead of keeping the pro-democratic ambassador. So we've got some serious issues, and so to discuss these issues, we've got Professor John Packer, who holds an endowed chair and directs a human rights and education center at the University of Ottawa. He is no stranger to Burma issue. He was, legal officer counsel to the very first UN Special Rapporteur on human rights situation in Myanmar back in the early 1990s, and he has been a champion of Rohingya cause for the last 20 years or so. And then we've got Professor Gregory Stenton, the formerly research professor at the University of George Mason University in Virginia, and he is a foremost expert on the genocide and former president of International Association of Genocide Studies or Genocide Scholars, and he was with the State Department, and he was very instrumental in establishing the extraordinary chambers of the Court of Cambodia, or otherwise known as Khmer Rouge Tribunal, and he has developed the almost universally accepted model for studying genocide, stages of genocide, and he's joined us from Virginia, where he served as founding director and founding president for the Genocide Watch. And then we've got Aaron Farrell Rosenberg, a distinguished legal practitioner, has worked in different capacities at the International Criminal Court, the International Criminal Tribunal for former Yugoslavia, and also she's currently the visiting scholar at the University of Cincinnati Law School, and also served as a senior legal advisor to the Nobel laureate Dr. Denis Mukwege's foundation that focuses on victims of sexual violence. So welcome to all of you, and my sincerest and deep appreciation and thank you for taking the time to discuss and your thoughts on these issues. Let me give the floor to Erin, who has prepared, her remarks, dealing with some of the fundamental issues. Erin, the floor is yours.
Thank you very much. And good morning or good afternoon, good evening to everyone joining us. It is truly a pleasure and an honor to be here with you. I'd like to start, of course, by thanking the organizer, Forcia and Dr. Zarni, for this important event. And I really look forward to the discussion that we will be having over the next hour with my two distinguished co-panelists. My opening remarks will not address whether the ICJ's decision is correct or its impact on the Gambia v. Myanmar case itself. These important issues will be amply covered by my co-panelists. Rather, in these remarks, what I would like to address briefly is whether the ICJ's decision to proceed with the junta for purposes of the ICJ case does or should have any impact on the issue of who lawfully represents Myanmar in other contexts, by which I mean at the UN and other international organizations or in bilateral relations between states. I think that it's important to frame this issue this way, because however one views the ICJ's decision in the Gambia proceedings, it must be understood first and foremost as a consequence of states' inaction and failure over the past year to dislodge the junta. Since last June, states have failed across all arenas through the United Nations, bilaterally and multilaterally, and here I refer to ASEAN, to prioritize policy actions that will actually realize the General Assembly's Resolution 287. This resolution contained the overwhelming statement of states that Myanmar's armed forces must respect the will of the people as freely expressed by the results of the general election of 8 November 2020 and allow the sustained democratic transition of Myanmar. This resolution is the clearest positive expression of the position of states as to the illegitimacy of the junta. But despite this clear and overwhelming statement, almost a year has passed without any progress. I think it's important to stop and underscore the point that this inaction of states in the international community has tremendously demoralized the Burmese people, who have repeatedly expressed feeling betrayed and abandoned by the international community. Just this week, over 280 NGOs in an effort coordinated by Crisis Action, the Global Justice Center, and numerous other organizations have called on the Security Council to finally hold an open session on the rapidly deteriorating situation in Myanmar. So, in conclusion, as to my first point, what I truly want to stress as we have this conversation is that ultimately the ICJ's decision is an unfortunate consequence of state inaction that demonstrates the continuing urgent need for states to meaningfully engage to resolve this situation in support of a return to the democratic process in Myanmar and for accountability for the crimes committed and which are continuing to be committed by the junta since the coup. So this brings me, Dr. Zerny, to my second point. Could the ICJ's decision have any impact, first legally and second politically, in other arenas on the international plane? Legally, this is quite clear. The answer is no. The only dispute over which the ICJ has jurisdiction is whether Myanmar has breached the Genocide Convention and its obligations thereto. Its jurisdiction in the case at hand does not extend, and it has no authority over the question of who lawfully represents Myanmar on the international plane, meaning at the UN and other international organizations or in terms of states. This is an incidental matter to the ICJ case itself. But the ICJ, and I want to really stress this, has no jurisdiction to decide this question as a general matter. I think that the law itself is clear. However, the concern and why this conversation is so important is not necessarily whether the ICJ's decision is legally binding, but whether politically it can be used opportunistically by the junta or other wavering states as a reason for the junta to be recognized as the legitimate representative of Myanmar. And here I would simply say, and we can discuss this during the next hour, that if you look at previous contested representation situations where international courts, such as the ICJ or the ICC, have had to, for their own proceedings, engage with one side, what we can see is that this has had no persuasive effect whatsoever on the position of states. And I'll just give one very brief example, the case of Venezuela. Now, in terms of the dispute around the Maduro regime and who lawfully represents Venezuela, the fact that both the ICJ and the ICC, in line with the UN Credentialing Committee's decision, continue to address communications and deal with the Maduro regime has had no effect whatsoever on those states that do not recognize the Maduro regime. So I think that it is important that we not overstate politically the likelihood that this could cause any state to change its position vis-a-vis the illegitimacy of the junta. And there is no reason to assume that an international court would have that type of effect. So conclusion, legally and in a realpolitik sense, the ICJ's decision to proceed with the junta should not be understood as having broader implication and does not provide a basis for legitimizing the junta. The final point, Dr. Zarni, that I want to make is you may be wondering, then why does it matter? Why are we discussing this if you are saying this has no impact legally or politically? And that is because the ICJ, unlike other situations, is, while only for the ICJ proceedings itself, it nonetheless is the only body that has actually made any type of determination in terms of representation. And it is therefore, in this isolation, a somewhat risky situation that, absent explanation from the court as to the limits of its decision, that this could be used opportunistically by the junta, not just vis-a-vis other states, which I think I've already addressed, but more importantly, in Burma itself, to confuse and demoralize the pro-democracy movement. So I think that it is important that the limits of this decision be communicated not only to states, but also within Burma itself. The Facebook case that we are currently seeing amply demonstrates the very real danger of the junta's use of misinformation to cause dissent and break solidarity in the Burmese community. And so I think that what is most necessary at this moment, if I can conclude with a recommendation, is that procedurally, the ICJ is unlikely to provide reasons for its decision until the judgment, the written judgment, which will not come for several months. I believe that there is a real risk of backlash to the Rohingya themselves, specifically in the sense that it could be erroneously understood that this decision has somehow undermined the pro-democracy movement. This perception pits the interests of the Rohingya against the broader pro-democracy movement and seriously undermines or could undermine the efforts at reconciliation that we have seen following the coup. So what I believe is important is that the ICJ be transparent, and that it exceptionally, potentially at the hearing itself, address the limits of its decision and make explicit that its decision to permit the junta to participate in ICJ proceedings on behalf of the state of Myanmar in no way confers legitimacy on the junta in any other context. If the court itself does not say this in the hearing, I would encourage the Gambia to take the opportunity in the hearing to itself put this on the record. The Gambia does not need to actually challenge the junta's role in the case, but it can, and I would encourage it to simply state the fact that the court's rationale in this case has no impact on the broader context of who represents Myanmar and does not constitute in any way recognition of the junta as the legitimate representative of Myanmar. So with those remarks, I'm going to conclude as I've tried to keep this brief. I look forward, as I said, very much to discussing these issues as well as the remarks of my co-panelists. Thank you.
Thank you very much, Erin. Can I invite Professor Stenton to offer his thoughts?
Thank you very much, Zarni. I am really honored to be here to discuss these issues because this is an important case, very important case. When I founded the Cambodian Genocide Project back in 1982, the only court that we could take a case to about the Khmer Rouge genocide was the ICJ, because there weren't any international criminal tribunals then. And when I researched this, I realized that we had an unusual situation. The Khmer Rouge continued to be part of the coalition that represented Cambodia in the United Nations. And this was because of the pathological politics of the Cold War, in which we, the US and UK and other Western powers, continued to represent a coalition that included the Khmer Rouge, the Royalists, and the anti-communist resistance. I likened it to a coalition between a collie, a poodle, and a wolf. And guess which one is going to dominate in that kind of coalition? Well, as a result, we were continuing to vote to seat the Khmer Rouge in the United Nations, and Presit was the representative, a Khmer Rouge. So in that case, we had the possibility of taking a case to the ICJ and actually having the Khmer Rouge have to respond to it. But that was a case in which the Khmer Rouge continued to be the representative of Cambodia, officially representing that chosen by the Credentials Committee of the UN. Well, this is a different case. This is a case where the Credentials Committee has tried to punt this down the field and say, we are not going to decide this now. And so you've got a pro-democracy UN representative who does not represent the junta. And then you've got, and he's still there in New York, and you've got the junta who isn't in New York and who, the question is it proper for them to continue to represent Myanmar in the ICJ? Well, the general rule in these cases is the ICJ has to accept the representative of a country that is recognized by the Credentials Committee in the UN. And in other words, it's not a matter that the ICJ really can decide. They are an organ of the United Nations. Never forget that. And so this is an unusually interesting case. Now, there is an advantage to their having to represent Myanmar because, after all, they're the criminals. They're the ones who did the crime. They're the ones who carried out their genocide against the Rohingya. But always remember this: the ICJ is a state versus state court. It's not a criminal court. In fact, it's not even, sort of the Supreme Court for the world. It is a dispute resolution court. And this is a case where all the ICJ has before it is to decide whether a treaty violation occurred, in which Myanmar violated its obligations under the Genocide Convention. So there are some advantages, actually, in having this junta continue to represent Myanmar in the ICJ. Remember this, however: the ICJ doesn't have to drop this case if, for some reason, the junta decides not to show up, because once this case has been brought, then the ICJ can still hear the case. I think it would be unfortunate if they didn't, if Gambia and had to argue, against an empty chair. But nevertheless, the ICJ could still render its decision. Now, I want to highlight, before we get into other jurisdictional issues, a couple of the dangers in this case. A lot of people are assuming that because the crimes of the Myanmar junta against the Rohingya were so blatant, so brutal, that surely Myanmar is going to lose this case. I'm sorry to have to correct your impression on that. The two genocide cases that the ICJ has decided so far, both of them, I believe, wrongly decided, the Croatia case and the Bosnia case, laid down rules of law that I think could be fatal to the Gambia case against Myanmar. The ICJ in those two cases held that genocide has to be the only intent of a state to find that it was in violation of the Genocide Convention. Now, I personally think that is an absurd rule of law. Is it even normal in criminal law that you would find, for instance, somebody who pulls a trigger on a gun, that he can't be found guilty of murder if he also had the intent to rob somebody? Of course not. In other words, this only intent theory of intent is just false. But the basic problem is caused by another decision that the ICJ made in those cases, in Croatia and in Bosnia. And that was to essentially impose what we would call, in an ordinary criminal case against an individual, a proof beyond a reasonable doubt kind of test. This is a clear and convincing test. In other words, if they can find there's any other intent, that's why they had this only intent view. If there's any other intent, then they can't find them in violation of the Genocide Convention. Well, as I've said, I think an only intent case, a single intent case, doesn't make sense at all. But what it does is say that if the intent was forced displacement, which, by the way, the ICJ called, quote, ethnic cleansing, which is a term invented by Slobodan Milosevic as a term for genocide denial. If they can find that was actually another intent, then they can't be found in violation of the Genocide Convention. In other words, that basic error by the ICJ could determine this case, because surely Myanmar had as another intent in its actions against the Rohingya to drive them out of the country. In other words, forced displacement, or what the ICJ called ethnic cleansing. This could be a fatal problem for the Gambia case. Now, there are a couple of other issues that I think we would need to probably think about. For one thing, the ICJ in both those cases, Croatia and Bosnia, applied what I would call an individual concept of intent. That's why they kept in those cases, citing cases from the ICTY, where Erin, by the way, is an expert. She worked for the ICTY. Well, individual cases are very different than a complaint against a state. How do you, after all, states don't have minds. You know, in an individual case, you're looking for the mens rea, the guilty mind. But states don't have minds. So how are you going to look for state intent? My view is you can surely look at the statements of the leaders of the state who have given the orders. That's one thing you could do. But the second thing, and I'd say this is a pretty utilitarian way of looking at intent, is you can look at a systematic pattern of actions that have the foreseeable consequence of genocide. That's what we've got here, a very clear case of it, in which both forced displacement and genocide were intended by the Myanmar regime. So those are my initial comments. I'm just worried about this case because if it goes forward and the ICJ stays on its current track, in other words, just goes by its precedents, Gambia could be in real trouble here and could actually lose the case.
Thanks, Greg, for pointing out some of the very basic fault lines that exist prior to the Gambia versus Myanmar, and how those fault lines may basically rock the case, despite unanimous initial just provisional measures are ordered rendered 2 years ago, I suppose 23rd of January. And so may I invite Professor John Packer to share his thoughts as well.
Thank you, Zarni, and thanks for the contributions of Erin and Greg. I'm going to take a somewhat different approach, and in some regards a little bit more, it might seem for some of the audience, boring elements, and focusing on some seemingly small procedure issues. But I'm going to begin by saying that international relations and international law are a bit abstract. The state itself as a concept is a construction composed of certain elements we'll talk about in a second. A government and what constitutes a government, systems of recognition and so forth are not the normal subject of the chattering classes. I mean, nobody knows, it's kind of, we accept these as statements of fact. But something that Erin began with, which I want to actually query, which is the idea that the ICJ has taken a decision with regard to the junta. I am unaware of that. I have seen no evidence at this point of any decision of the ICJ whatsoever, other than they have given notice last week of the case proceeding referencing the states. But I have yet to see, unless I have missed it, a statement of who is exactly acting for each party. And the specificity here is really very important. In particular, who is the agent and who has the court communicated with for example, if they have changed the previous agents who weren't and counsel who are notified to the previous proceedings before the court, then what is the basis of those decisions? This is very kind of boring, but crucial to see. There is an assumption and certain kind of rumors that the court is engaged with representatives of the junta and that they are proceeding as such. We don't yet know that. And that's, I think, one of the reasons Erin is demanding essentially transparency, which I agree with. I mean, it's kind of absurd. Otherwise, a very simple question. Can you and I show up and say that we represent now Myanmar? Because, we know a lot of people from Myanmar, and Mang Zarni is originally a Myanmar citizen. So let's us represent the state. That's not how international relations function. That's not what international law says. So let's begin with the simple question of the state. There's no doubt about the state. So anyone who's querying, what does this mean to the state? There is no dispute that Myanmar as a state exists. It was created on the 4th of January, 1948, immediately recognized and subsequently recognized by many states, and admitted to the United Nations as a member, and a proud member. And by the way, it voted that year for the Universal Declaration of Human Rights, proudly. So Myanmar as a state, the state itself is defined in a treaty. So as Greg said, we're in the very clear domain of treaty law. States are defined by something called the Montevideo Treaty Convention, 1933. And it defines that a state is comprised of 4 composite elements: a defined territory, not perfectly. I mean, Canada's territory is in dispute, the Arctic, in dispute, incidentally, with our American neighbors. Is the Northwest Passage internal waters of Canada, or is it international waters? So first of all, let's get out of our head that there's perfect definitions, but approximatively we accept Canada exists. Canada is defined by its territory. The second requirement is a permanent population, meaning not a transient one or coming and going and uncertain. And the third element is a government, an effective government, with the fourth element that's probably constitutive here, which is the capacity to enter into relations with other states and be held responsible. That all means that it turns on something called recognition. There's a whole theory then about, is recognition constitutive? Does that make the state, or is it merely declaratory? But what is recognition? It is the perception and decision of other subjects of international law, meaning other states, to confer the recognition. Now, does this work perfectly? Quickly to say, we've got a bunch of states in the world that would meet those first 3 criteria and are in dispute on the 4th criteria. We could talk about Abkhazia, the Turkish Republic of North Cyprus, Somaliland, Taiwan. I mean, and we could go on and on. So there are many uncertainties about all of this. In the case of Myanmar, there is no uncertainty. The state is clearly defined, permanent population, and it is a member of the United Nations. The issue now is the effectiveness of a government and its capacity to be held responsible. And now specifically in the context of the UN under the Charter, and before a court, which is, as Greg underlined, the judicial body, not of outer space or of its own invention, but of the United Nations. Its own statute is annexed to and forms part of the UN Charter. So the ICJ is not a free agent that can decide whatever the heck it likes for whomever, never mind consequence. Okay, now, if we're looking at government, there was no doubt about the government before the ICJ at the commencement of this case in 2019. The doubt arose on the 1st of February last year as a result of a violent, bloody military coup d'etat. Coup d'etat is not a legal term, incidentally. It was a usurpation of power by physical force unlawfully, first under the prevailing law in Myanmar, the Constitution of 2008, I'm trying to remember, 2008. But also, in my view, unlawfully at international law. There was the actual conduct here. We'll come back to that in a moment. But most importantly, it's been disputed. And so we have a situation, a prevailing situation, where there's a dispute. So we turn to recognition, and there are 2 questions in recognition. One is the procedural competency of the organs. And in this case, Greg has already referenced something called the Credentials Committee. So in the UN General Assembly, every year to decide who gets to sit and who gets credited as sitting in the seat and speaking for the state, because the state is a construction, right? You need actually a person. So who's the permanent representative and so forth? There's a decision taken. And the state submits documentation and tests who those persons are. So we have the ambassador, permanent representative of New York. And so a decision is put to the General Assembly from this committee, comprised, I think, of 9 states. And then the General Assembly votes, and it's a vote. Okay, not always in dispute, but there's a long history of dispute. This year, the ambassador, the permanent representative, said that he is staying in the seat of Myanmar, and the Credentials Committee actually permitted him to remain. So there's actually a positive decision that his immunities and privileges remain. And at the same time, they said, but you may not sit in the seat and vote because there is uncertainty in a dispute. They put in abeyance the actual operational decision. I want to underline at the same time, this ambassador was subject to an assassination attempt by, it appears, agents of the junta. So let's just be very clear about what's actually happening on the ground. No, to my knowledge, I think 4 states have recognized the junta. And let me just say that there is a doctrinal question here, whether in international law, states recognize other states or recognize governments. This is a fictional doctrinal nonsense. Of course, they recognize states, but when you and I know that heads of state call each other to congratulate heads of government on electoral victories and all that, they are in fact recognizing governments. That's why there was hesitancy in November last year regarding Trump Biden for a moment, and why it was very important that there were actually these exchanges. And because that's who they actually have to work with. States have to actually work with real governments that have representation. Okay, so we have some uncertainty over this, and I just wanted to be clear what the actual situation was. The ICJ statute does not define the exact procedural mechanism for deciding such a dispute, but it does not confer a competency on the court to decide of its own bases, absent law, such a decision. The court is in fact duty bound to follow in accordance with law. That means international law, and it certainly means the UN Charter. However, the statute does provide in Article 38 and a couple of other articles specifically that agents must be identified, and they identify who the parties are, diplomatic representatives of the host country, or other, and I'll quote you, some other duly authorized person. We don't know what the heck that means, to be frank, but usually it also means, and it says that this must have the signature authenticated by either such a person or the applicant and the respondent's foreign ministry. So who is, that begs questions, right? To my knowledge, as of 1st of February, not only the agent of Myanmar was Aung San Suu Kyi, but the foreign minister of Myanmar was Aung San Suu Kyi. She appointed herself. And to my knowledge, there has been no formal change of those positions. I'm not aware of a resignation. I'm not aware of a recognized foreign minister having superseded and so forth. I am unaware of the ambassadors, the representation of Myanmar in the Netherlands. What I do know is the Netherlands' orthodox position is they do not recognize a government, they recognize a state. And so there is a question, who is the diplomatic representation of Myanmar in holding status in The Hague? And is that the person the court has communicated with? Now, let me just, a couple of things quickly, because time is passing. For those people who think, oh, but the case must proceed, it's imperative, whatever this complication is, because important decisions may be taken. Let me first of all say, these questions are not new. Younger people may not be aware that at the end of the Second World War, Germany had no representation in the United Nations until 1973. And it was then admitted pursuant to, because there was no peace agreement with the Germans at the end of the Second World War. Germany was then admitted not as a single state, but as two seats. And later in 1990, they of course joined into a single state. China was admitted, of course, as an original member in 1945, initially with ROC, Republic of China representation. 1949, there was a revolution. It was not until 1971 that there was a change of representation. Of course, we know this dispute still exists. Taiwan still has unrecognized representation in offices, for example, diplomatic representation, but not the seat. The seat is held by PRC. My point is only to say that there's no imperative that this must be decided in 2 months, 3 months, next year. We have to look at what is the law and what are the implications. Now, in the terms of the law, this case is not merely a dispute between two neighboring states that have an argument over some interest between themselves. In fact, the position of Gambia, the sole position of Gambia, is that its position is entirely erga omnes, a public interest action on behalf of the international community. And it acknowledges in so acting that it has no other interest, and therefore its only interests are inimically connected with and inherently connected with the interests of the community of international community of states. So we know that there are potential prejudices on the international community here of this case, not limited to these two states. And that's not to even mention the Rohingya. The Rohingya have no standing in this case. They are the victims of the case. In my view, they're being treated as an object in dispute, I think reprehensibly, and also not consistent with the UN Charter. So what then do we look at? We must look at consistency of the ICJ in its conduct as a body serving states under the Charter. It should surely not be contradictory to the other organs and principal organs of the United Nations, such as the UN General Assembly. It should not be prejudicial to those decisions. It should not be prejudicial to the interests, rights of other states. And I say rights because under a multilateral treaty, under the ICJ statute, a treaty like the Genocide Convention confers not just the possibility of acting on interests, it confers rights of all 150 other states parties to the treaty to act. And these are about to be prejudiced, because if this proceeding takes place now on this uncertain term, there will be consequences. With due respect to Aaron, there will be consequences, both legal and political, because, for example, as the case proceeds, the rights, for example, under Article 62, the right to intervene, loses its opportunity. States are prejudiced in their ability to assess and so forth. So concluding here, what should be looked at? There are principles of international law and of the UN Charter, a treaty. The principles are not just about the authenticity of UN member states in their representation and their authority, following the authority, but also of the effectiveness of this. So first question is, who has effective control as a putative government of Myanmar? It is dubious, to say the least, that anyone definitively can lay that claim. And actually just the other day, I think 2 days ago, International Crisis Group issued reports making very clear that not only the junta is not in full and effective control, it is slipping out of effective control, which raises another question. The third point is legitimacy of that authority. Under the UN Charter system and the Universal Declaration, for example, Article 21 says that the will of the people shall be the basis of the authority of government. The will of the people has only been expressed fairly unequivocally on 8th November 2020 in a election, flawed election, but still the only election, clearly in favor of the NLD-led government. Certainly not in favor of the junta, and in fact, to the contrary, all the events subsequent to that. But if there's any doubt about that, we would have to look to Article 55 of the UN Charter. Article 55 of the UN Charter requires states in good faith and in terms of fulfilling their obligations to the objects and purposes of the convention, the Charter, to act in favor of the well-being of the population. There is no credible basis that the junta can argue at this moment that its conduct in the face of massive civil disobedience, ethnic armed groups, separatist movements, so forth and so on, the abusive use of state power regarding COVID, and we could go on and on and on. The argument that the junta is acting on the basis of the well-being of the population is an absurd statement and would be a ridiculous position of the ICJ. But finally, the prejudicial issues, and I want to really underline this, because the prejudicial issues here are many. The arguments that the junta may place, for example, they will contest that the Rohingya are a protected group under the convention. They will contest that there's any genocidal act whatsoever. They will clearly dispute any duty to repair. These are radically different positions than have been, at least so far initially, articulated by, for example, the National Unity Government. I'm not arguing the National Unity Government is meritorious to succeed. I'm simply saying that there is at least known alternative positions. And those alternative positions entail things like admissions that there has been genocide, admission that the Rohingya are a protected group, and the possibility of negotiations on reparations and so forth, which are hugely important and should not be subject to positions that would be prejudicial. There is no compelling reason for the court now to take a precipitous and prejudicial position that will cause harm, And for the court to do so is not only contrary, in my view, to not in accordance with law, it risks to subject itself and to the United Nations to ridicule and to damage to the ostensible group to be protected here, the Rohingya. Thank you for allowing me my initial remarks.
Yeah, thanks so much, Professor Packer. Let me just chime in for 1 minute. That we've got an extremely unique and unprecedented scenario insofar as the genocide cases. You know, and as you know, international jurisprudence on this case is very, very thin. There are less than like 3 cases that the ICJ has pursued in the past with, I would say, like a deeply unsatisfactory results for the victims as well as those accused. You know, the Bosniaks were not happy with the fact that the court did not find the state of Serbia, not having perpetrated genocide. You know, it's only the killing of almost 8,000 Muslim men and boys at Srebrenica were considered a genocidal act, but as a state, Serbia was allowed, to walk scot-free. And but that aside, what Aaron was saying is that there were other the cases where the court was able to contain or be circumspect about the spillover impact, which is the diabolical and dodgy regimes manipulating and leveraging the fact that they were allowed to represent, say, like state of Venezuela, as a basis for legitimation in other branches of the United Nations. And then what John's saying is that, that sort of surgical, the judicial proceedings are simply not conceivable. And what I want to add is, like, we're looking at actually a particular region, not simply the Myanmar as a bounded space as a whole. We're looking at, let's just say, Western Myanmar, from the international criminal perspective, the site of the crime, and Northern Arakan. And there you have basically 3 claimants. One is the National Unity Government that attempted to reverse radically the National League for Democracy and Aung San Suu Kyi's position by recognizing Rohingya by their group identity and offering reconciliation, and also appointing even a Rohingya as an advisor, something unthinkable only 1 year ago. And so you've got NUG contesting the right to represent the state of Myanmar. I don't know what NUG's National Unity Government or the contesting, the democratic government's position will be in terms of the merits of the case, but they are contesting nonetheless. And then you've got the Arakan army that has claimed that it has 60%, not 50-50, 60% of the effective spatial and administrative control of the Western Burma, which is the focus of the ICJ's provisional measures order, right? And then you've got the double taxation going on. You've got the government, military's police, military's the taxation system, and so Rohingyas, the subject of the court's concern beyond state dispute, is subject to 2 different regimes of taxation, administration, and law enforcement. Right? This is an extremely unprecedented situation. So in that situation, the court is inserting in a highly risky way, as John pointed out. So may I invite both, Aaron and Greg, Aaron first and Greg. And so, we will extend this conversation for, 15 minutes if we need to. It's such an important issue. And so, Aaron?
Absolutely. And let me be clear, because I think John has a bit misstated my position and created perhaps an idea of disagreement that in fact does not exist. My remarks are not at all addressing the actual rightness of the decision, as I said, or the impact on the ICJ case, which I consider to be potentially quite enormous. What I do think, and I want to really reiterate this, is that the impact of the ICJ's decision at the United Nations with other states in a multilateral setting is a political issue. So I am making a very clear political advocacy statement. How the impact that it has is in the hands of those in the international community who are looking at what the ICJ is doing. And what that means, to be very blunt, is that it is incumbent upon NGOs, all those who are involved in the trying to resolve the Myanmar situation, to proactively and very clearly prevent the junta from using any role at the ICJ in terms of claiming legitimacy in any other arena. It is basically the international community that can render this point null. And it is therefore very necessary for the international community, other states, but the NGO community as well, to be crystal clear. Whatever the ICJ has done, whether it is a correct decision or not, the damaging implications it may have on the case aside, it should be said clearly it has no impact on any form of legitimacy being conferred on the junta at the United Nations or from states. Thank you.
Greg?
Yeah, thank you very much. Thanks for clarifying that too, Aaron. And I just wanted to also thank John for so clearly, as usual, laying out the law of recognition and how, governments are recognized as representing states. It's treaty law. It is international treaty law. And and I think he's absolutely right that this does have implications here. And as Aaron has just pointed out, it could be used by the current junta if the ICJ, allows this case to just be argued the way it currently looks like it's going to do. In fact, my recommendation here is, just like the UN did, kick this thing down the field. Wait until the Credentials Committee decides which government should represent Myanmar in the ICJ. I think John's absolutely right that the situation has changed since the case was first filed in 2019. It is now far from clear who should represent Myanmar in the ICJ. And if the Credentials Committee decides that it should be, somebody besides the junta, it could have a huge impact on how this case comes out. Personally, I'd love to see, a different government say, yes, in fact, genocide was committed by our prior government. Our state did commit genocide. We hereby confess. And now let's talk about reparations. That's what should happen here. And I hope that the ICJ will have the wisdom. And I hope, by the way, that the lawyers for the Gambia will have the wisdom to ask for this. I've been very disturbed, in fact, by the fact that so much of what's happened in this case has been kept secret. Why haven't we been able to read the reports that Myanmar's supposedly been filing with the ICJ about how it's following up on the provisional measures? Goodness gracious sakes, this should be public. Also, I personally think that things like the memorials that the states file in the ICJ should be made public as well, because this is very important. And Aaron's so right that this is a political decision that needs to be made by the Credentials Committee. And John has laid out, he's laid out the basis, the legal basis on which this political decision needs to be made.
Yeah, I think in this case, it's possible that both arguments are right. Depending on where you want to put the emphasis on, right? And that both A and B can be right. It doesn't have to be A is right and B is wrong. But the 2 points I want to comment as a Burmese, and there's someone who came from an extended military family and very familiar with the military strategic thinking. They're not looking at this from a legal perspective. They're looking at this from a strategic perspective. Yeah. So the best way to understand the Burmese regime and its strategy, and the regime as a creature, if you will, it is a very, very experienced fish that has learned to eat around the hook. So from the Burmese perspective, as absurd and Kafkaesque as it may sound, this is a party that they would like to attend. They are jumping up and down to go to the party. Yeah. But, in a normal, the mental people with normal mindset would think that it is shameful that we have to go to defend the state of Myanmar at the ICJ against the serious and credible allegations of genocide. No. They are so happy that they get to go there because they're not stupid, because they are looking at the entire UN system holistically. They are brutal, they are cruel, but they also do their own thinking. Do not underestimate the military's strategizing. They look at the final scenario. What is the final scenario? The court renders that the state of Myanmar has commissioned the crime of genocide. So what? Who is going to enforce this ruling? And Security Council has two very solid friends and arms dealers, like Russia and China. China would defend. China itself is committing genocide. Russia is about to violate international law, by its threats against Ukraine, right? And so the junta look at everything. All right, look. Consider that we lost the case. We are found, the state is found guilty, but what's going to happen, right? Short of triggering Chapter 7, right, and the Security Council authorization, which will never come on Burma, on the doorsteps of China. So from the junta's perspective, this is the party they must attend, right? So the other point is both John and Greg talk about Rohingya being objects, right? Well, whether it's just simply crimes against humanity or the crime of all crimes, genocide, this is something that concerns the entire human race. Why is the code acting like a 15th century Catholic church? Everything is opaque and secretive, right? So that is the nut we need to address. And then finally, my comment is the court is actually taking the risk that can seriously damage the court itself as the judicial body of the United Nations. Now, like it or not, the highest court among 193 states. Yeah. And so can I invite John, to respond to all the issues that are surfacing as aside from the merits of the case, the legitimacy of the state actor or lack thereof.
And Zarni, if I can just jump in before John speaks, I would like to very much address a number of points on reparations after John has spoken.
Okay, yeah, sure. We will extend, as much minutes as we need to. Because
I very much want to hear Aaron on reparation, because I think this is actually reparation from the victim's perspective, but also in terms of international relations and international law. This is actually the really important part of the case. What can be done, what should be done, and so forth. But let me emphasize again. I agree very much not only about the need for transparency, but I love how you've just phrased or framed, Zarni, the character of the junta and eating around the hook and so forth. There is no doubt, and it has also been already stated in a number of reports, that the junta seeks the stage of legitimacy of, for example, the court. And if they are cooperating, Why are they cooperating? Not because they relish to be the subject of the accusation, but because they want the stage. I think there's no doubt about that. But let me go back to something, if you allow me, just a bit. In international law, there is, and in all of law, there is no law absent politics. That is a fiction wrongly taught in law schools, frankly. All law has a political character. But in international law, it is an intimate and sometimes explicit connection. So, for example, the Security Council simultaneously determines politically and legally whether there is a threat to peace and security. It is the same act, simultaneously political and legal. And there is a doctrine that the Security Council has the competency to determine its competency with regard to this determination of peace and security, what it may consider, not consider, and so forth. There is no such arrogated authority, or there is no such authority that the court seeks to arrogate to itself on this matter. The court cannot decide who the heck it wants to allow inside the court. It must follow, and explicitly, even the notice it issued last week specifically says, and I quote you, the court acts in accordance with law. What is the law? The law is essentially the charter. So this is not a matter of just politics. This is law, and the consequences are legal, even if the decision is political. And the court should not be making a political decision. Now, to go to the other questions, there are very big issues here. We are living in tumultuous times. There are right now contested fundamental norms, not just of the charter, but of pre-charter normative character. For example, territorial integrity and respect for frontiers. So we're talking about Westphalia. We're talking about 350 years of international law right now hanging in the balance over some of these matters. And we need all the judicial and other instruments of international rules-based order to be effective and to be have the character of law, which is to say legality, foreseeability, and to engender confidence. None of this helps with the court being untransparent and then making decisions like this, which not only raise numerous questions, but quite literally subject it to a ridiculous situation. What's the ridiculous situation? It is not beyond doubt. In fact, I would say there is a fair degree of even foreseeability that the junta, in a matter of months or a year or two, may no longer be in any effective control. In fact, the very specific agents they have, because they're almost all now generals who have been put into political positions, may find themselves in other judicial bodies. But there may be something else. It's not out of the question that quite literally the week of the hearings, there could be another coup in Naypyidaw or in Yangon. I'm not betting on it. I'm not naive and suggest. What I'm saying is it is extraordinary that the court should itself conduct itself in a naive way where there is manifest, palpable uncertainty and the risks are high to take such decisions that are prejudicial, that are potentially precipitous, and that may subject itself to ridicule. That is just gobsmacking. I don't know what the thinking is in the court. And the alternative argument has been, well, the case must move along. For whom? For what purpose? For some guys in black robes? For a party in The Hague? What you mentioned the party. That's what I'm saying. And by the way, yes, cocktails and all the rest that go with those meetings. But I also want to emphasize what could be here. And Greg is absolutely right. If we're looking at the seriousness of the case and the seriousness of the times, there is an enormous opportunity here for the case to be led a different way. And that is to say, in the public interest, to look at the creativity of the instruments before the case. What are the potentials, for example, to establish a commission of inquiry? What are the potentials to use the proceeding? Another representative, Myanmar could come to the court and say, we admit not only the Rohingya are protected, we admit genocide occurred. Now let's parse that. What specific acts and conduct and who exactly within the state are the acts and responsibilities at their feet? And in addition, what would be a process to actually address this, which meets the public interest, which is not only the repair, but the most important element, not to repeat it. So what with the institutional question and so on, all of that is actually within the grasp of the court. I know it's not a arbitral or a negotiation, but the court has, for example, mechanisms to my knowledge it's never used, such as a commission of inquiry. A creative approach could lead to that with a party that actually says, let's discuss it, let's look at it. Because, and I'll end with this, even admissions by Myanmar would not end the case before there are elements in dispute, including a public interest, which are not resolved merely by Myanmar saying, right you are, we'll write a check, goodbye. It depends what is actually presented. The arguments actually matter. The positions of the parties matter. So that's why we cannot just shrug our shoulders and just say, oh yeah, let's move along the case.
Thank you, John. Erin?
Yeah, thank you. And let me be very clear. I just want to, before moving to reparations, to suggest as a lawyer that it's always good to be aware that you can make your argument and make your request, but you should be prepared, if that is not granted by the court, to have a counter strategy. So while I do not disagree with any of the very fundamental and profound points that are being raised about why it is perhaps unwise and, as John would argue, even unlawful for the ICJ to proceed in this manner, I would strongly suggest, in a very realpolitik, but also just strategic lawyering sense, to understand that if the ICJ continues as it appears that it is, that there is a very serious need to ringtail and limit, mitigate any impact of the ICJ's decision. So I really want to underscore that point to those who are listening. All is not lost.
I fully agree with that. Just to be clear, I absolutely agree with that.
Thank you. Returning to, and I know we're running late, and I think we could do a whole nother discussion for hours about reparations, but I do want to say something about this, because I think that there is an opportunity for the court to take a very different approach from it has in the past. For those watching, it's important, I think, to understand that much of what is said about reparations does not comport with the reality, particularly procedurally, at the ICJ. And there are expectations that may not be met in reality. This week, we have been notified by the court that in the DRC Uganda case, that there will be, finally, there is a decision on reparations, which has been eagerly awaited and quite patiently awaited, 20 years waited for. So I'd like for everyone to understand the length of time that reparations proceedings take. And I don't want to extend this conversation too long to get into a conversation about forms and modalities of reparations. And I want to just focus for a moment on the issue of the actual procedure and the amount of time that reparations proceedings take, and when realistically you would even be able to think about there being actual real reparations available, leaving aside the issue that a whole nother nut to crack, that reparations at the ICJ are state v. state. So there's a whole question of how ultimately this even gets to the Rohingya themselves. But let me just say this, at the ICJ, in the context of provisional measures, I think that it's well known that there's been a fair amount of valid criticism around the efficiency, effectiveness of provisional measures at the court coming from the Bosnia case. As we all know, the complete lack of effect, if you will, of the provisional measures there. So the court has created a reform committee, I believe composed of judges at the court, to oversee and monitor the implementation of provisional measures orders. I would reiterate the call made by both Greg and John that a part of this, it is really necessary that the provisional measure compliance reports be made public. And I would hope that we actually see something in terms of some type of evaluation of whether or not Myanmar is actually, or the junta on behalf of Myanmar is actually meeting its obligations to implement the orders. But at the same time, there is and I'll close with this, there is an opportunity for the court to be proactive, to be thinking ahead. And I would strongly advise the consideration of creating a similar panel of judges that would look at what are the deficiencies in the actual implementation of reparations at the ICJ, what procedural changes potentially to the rules should be made, and how can we, so that at a later stage, we are not caught in a situation where there is an expectation of reparations arriving, and in fact, it is a very confused and slow process. Changes and reforms can be done now, and they should be, because it is truly in the interest of victims to do this now, rather than to have them involved in a fight for their rights. Let's have it be that when we get to that stage, they are able to access their rights rather than having to fight procedural battles. Thank you.
Yeah, all three of you are in full agreement with the need for the court to be transparent, because the court is there to serve the greater interest of all of us, that are part of this UN system. And I want to just ask Professor Stenton about his old colleague from the International Genocide Scholars Association, Bill Shabazz. Yeah, Bill Shabazz has made waves with his decision to defend and deny genocide. Right. Whereas, in fact, in the past, he was one of the leading voices, pointing to the genocidal direction in terms of Myanmar's persecution. Around 2010, he published out of one of the Irish universities' Human Rights Center, the empirical study of the situation, and call it the crimes against humanity in Western Myanmar. And then later, he more than hinted that Myanmar case was in the realm of genocide. It's no longer frivolous to call it to use the word the genocide. And so apparently, according to the Burmese news report from the Radio Free Asia Voice of America, I believe, Bill Shabazz is no longer representing the state of Myanmar, aside from who should represent Myanmar, right? So, can you comment on the international lawyers' role here, because we still don't know which international lawyers will represent the junta's legal team.
Thank you. And it's good that you asked me, because I was the fool who asked Bill Shabazz to be my successor as president of the International Association of Genocide Scholars. Now, he's a very distinguished scholar, as some would say. But on the other hand, my view is that his definition of genocide is a very narrow one. And that, in fact, right in his own treatise, and in both editions, in fact, he says, and I quote, "Ethnic cleansing can never be genocide." Well, he's wrong. The truth is, and that, by the way, is the origin of this only intent theory that that the ICJ used in its Croatia and Bosnia decisions. Bill knew very well that his treatise would be sort of the first on the block. And so he knew it would have a huge influence, and it has. This problem is, for him at least, for Bill, he sees intent, I think, the way a individual criminal lawyer would see it, and not as something where the state can have multiple intents. And absolutely, states always have multiple intents. By the way, I think individuals do as well. So I think that's one of his problems. the other thing is because he tends to sort of go back and forth in his definition of genocide. On the one hand, he recognizes that the convention is, the law on it. But then he turns around and in the Uyghur situation, tries to say, oh, no, really, genocide is just mass killing. Ignoring, the other acts of genocide that are specifically listed in the convention. I ask him, have you read it lately? Have you read the convention lately? Because it includes, creating conditions of life that are intended to destroy the group or causing serious bodily or mental harm to the members of the group, preventing births within the group, taking the children away from the group. My goodness sakes, the Chinese are doing all of those things. So of course that's genocide, what's being perpetrated against the Uyghurs. And yet he, decided to write an article trying to say, no, the Chinese are not committing genocide. In fact, and this is a real concern of ours, 5 presidents of the International Association of Genocide Scholars wrote him a letter when we found out that he was going to represent Myanmar in the ICJ. And we said, please don't do this. We said, how can you do this? We understand your argument that everybody deserves to have a lawyer when they have to go to court. And absolutely, I'm sure that Myanmar is paying him plenty to represent them in the ICJ. And I don't argue with the idea that that a person has a right to the lawyer when they go to court. But that doesn't mean that an individual lawyer has the duty to become that lawyer. I think you have a moral duty to look at the regime you're representing. And that was our point in our letter. We said, this is a regime that has perpetrated some of the worst crimes against humanity, and we believe genocide, that have been perpetrated in the world since the Second World War. How can you do this, Bill? Please, stop representing them. Well, as you know, he has decided to stop representing them. But what really troubles me is that he also denies a number of other genocides that, in a lot of our views, scholars of genocide, are pretty clearly genocide. The Holodomor in Ukraine, for instance, carried out by the Stalinists. The genocide in Cambodia, which not only was genocide, of course, it was also huge crimes against humanity, but it was genocide also against Vietnamese, against Buddhist monks, against it's another, and the Cham Muslims. I mean, here we had it. And so, in other words, he's become something of the world's leading genocide denier, which really, really worries me.
Yeah. Greg, sorry to interrupt. I think that, if Bill Shabazz, whom you rightly call the world's leading, genocide denialist, finds Myanmar regime unrepresentable, unworthy of carrying on denying, why would 15 judges on the bench find this bunch representable? You know what I mean? Of a state. This is, you've got, this is not a criminal case. It's not like defense or
that's right.
The prosecution. There's no defense, no prosecution. The
right.
Two parties in conflict or dispute. And so even Bill Shabazz found it, deep inside himself, that to continue to stick with this regime. Yeah.
Zarni, if I may say, I don't think it's clear. I don't think it's clear how he has his position. I don't know if he.
No, that's right.
The junta may have chosen not to retain him. Yeah. We don't even know if he's ever been paid. I do wish to say that I appreciate all the observations Greg made, but I think it's a broader question. First of all, I do wish to say that I believe that as an individual, Professor Shabazz has made an enormous contribution over a 40-year career, and done a lot of great things. I disagree with him on a few points. I've debated him, obviously, and by the way, I share the views that Greg just expressed on substantive issues. And there is a kind of strange, seemingly now perverse effect that we are observing. But I would like to generalize that because I think Professor Shabas is a little bit reflective of a broader problem. There is an insular community of international jurists who are living, thinking that there's an enormous disconnect between their world and the procedures, in a rarefied place like the Peace Palace in The Hague, and what's actually happening in the world. And I don't just mean on the ground in northern Rakhine State and so forth. I mean, politically, that's the disconnect. If the judges with what's going on in New York, that's the disconnect. So I would generalize it to say we have a problem here. And I think you've spoken about this before, Dr. Zarni. There's almost a little cabal. It's not a little cabal. It's a known group of people who are not acting in the spirit of and the need of contemporary international relations and law, and not justice. The concept of justice here, justice for the Rohingya, justice for the affected people. You mentioned, Rakhine, the Arakan army and so forth. There are big issues of justice there. So this disconnect, I think, is what I would rather draw attention to. And this is a reason why the court, in the case that we're discussing, needs not only to be in accordance with law and scrupulously so, because that is their legitimacy, but it needs to be transparent about it. And the idea, I love in the negative sense your reference to a 15th century Catholic chamber, but they're behaving that way. And that is not either pursuant to the charter nor in the spirit of international law or the concept of justice.
And I would add one thing here, and that is the same is true of the State Department. The legal office in the State Department, after I worked in the State Department, and had to deal with these issues, I began to call it the Office of the Legal Advisor on Genocide Denial, because every time a genocide would happen, they would try to deny it. The reason was they decided they would like to make our foreign policy. And so if they could deny that it was a genocide, maybe we could keep the US from intervening or doing something powerful about it. Well, the lawyers are not supposed to be making foreign policy in the United States. They're supposed to be advising those who do. Well, we had to face this. And guess who it was who was the main lawyer who was in denial about the Rwandan genocide in the State Department Legal Advisor's office? Joan Donahue. She was the leader of that group who said, don't use the word genocide for the Rwandan genocide for 3 months, and who instructed Christine Shelley and the other spokespeople for the State Department to not use the word, to call it acts of genocide or something like this, until everybody finally read the convention and said, you know what? Genocide is defined as acts of genocide. In fact, I think Warren Christopher made that judgment. But the point is, Joan Donahue is now the president of the International Court of Justice.
Whoa.
In other words, you are not punished for legal malpractice, you're promoted. And so we have a real problem here. And it's not just, I don't just mean to personalize it on Joan. I mean, we have a real problem with genocide denial. And genocide denial isn't just, true in the ICJ or in the State Department Legal Advisor's Office. It's also true at the United Nations. It's true a lot of places around the world, including among many legal scholars who I think are confused about a number of issues on genocide, including the concept of intent.
Yeah, well, you've got, across the river from where you live, you've got the State Department is still having chosen not to call the Rohingya genocide a genocide.
Yes.
And then the Trump and Biden, doesn't matter whether it's Democrat or Republican, they use genocide as a political tool rather than the judicial determination, right? You've got a State Department that authorized this serious study at the cost of over $1 million and shelved the findings because the findings did not suit them. And so the Tony Blinken and Joe Biden, they've been to the country, but they've never use the word, whereas in fact they were tweeting like mad about, like, what the Chinese Communist Party is doing, which is genocide. It's not that I disagree, but I agree. But you don't have to pick one one case, a genocide, and then completely shelve another because it doesn't suit your geopolitical interest. And so the final word is reserved for Erin.
Thank you. Sorry, I was trying to get myself off of mute there. Well, thank you for that. And I really appreciate the remarks of my co-panelists, as well as you, Dr. Zerny, about the incredibly serious potential implications of what's happening at the ICJ, but also the broader issue of Holocaust denialism. Today is the International Day of Remembrance of the Holocaust. And so this is a particularly timely conversation. Holocaust denialism, genocide denialism is an issue which is actually getting worse, and that's quite heartbreaking to many people who care deeply about these issues. And I guess what I would say in conclusion is, I think that in that sense, that the international community, states, activists, everyone really, I hope, will take this opportunity to reflect on not only achieving justice for the Rohingya in the genocide that took place, but also reaffirming and strengthening commitment to ensuring that there is not a reoccurrence of genocide, as the ICJ itself and the Gambia have both stated is the situation now, today, that there is a serious risk of genocide reoccurring. And so I think that my final comment would just be, despite all of these very, sort of troubling indications and the troubling times we find ourselves, we have to rise to the occasion and really redouble our efforts, both in terms of past accountability, but also most importantly, in terms of preventing further genocides, and that is in terms of the Rohingya and all those who are at risk. Thank you.
Thank you so much, Erin. And that's why we picked specifically the International Remembrance Day, which falls on the day Auschwitz was closed or liberated by the Soviet Red Army, today, 27th of January 1945. And we are a group of people who really believe in the never again, and it has to apply universally across Muslims, Jews, Buddhists, atheists, communists, capitalists, everybody. Assault on one group of fellow humans is an assault on all of us. So that in that spirit, we are closing today's roundtable by three very distinguished legal minds. Professor Gregory Stenton from Virginia, the Erin Farrell Rosenberg from Indiana, and the Professor John Packer from Ottawa. Thanks for getting up early enough to join this, and we'll speak again.
Thank you.